Hello, everybody. We are excited to have David Height with us, the Assistant Director of Debate at Carrollton and the former Assistant Director of Debate at the University of Michigan. Talk to you today about the criminal justice reform topic. Every summer, David gives the topic lecture at the beginning of the camp, and then again a few weeks later. And it's pretty exciting to see how his views on the topic morph over a few weeks. So we look forward to this talk and then the next few that he will give everybody.
Welcome, everybody. I am excited to have the opportunity to give this talk. I'm going to speak probably for between 20 and 30 minutes, and then there'll be a time for questions at the end. I'll say the caveat is, well, when I normally give a topic lecture, I will have had a lot more time to have done research and background reading, usually about, almost 2 months of additional time than what I had here. But I have done a lot. I've actually written a couple of files so far, and I've read a lot, so I'll do my best to answer any questions that you have. But it's certainly possible that, and likely even that for a lot of questions I won't know the answers at this particular time. My goal here is I'm going to do 3 things. I'm going to talk a little bit about my thoughts about the topic and what it means, what I think that it's going to look like over the course of the year. I'm going to give you a little bit of introduction to some aspects of the topic. The topic is very, very large. And then I'm going to give you a couple of research ideas at the end of ways that you can hopefully increase your own knowledge about this topic. So the very first thing that I do whenever I approach a new topic, well, I actually do 2 things, or think about 2 things initially. So like number 1 is just what is the plain meaning of all of the terms in the topic? What do these terms, what type of ground does it give for the negative? What types of affirmatives exist? Is there anything that the affirmative must do in order to be topical? And then the second thing that I ask is usually just like, what is the core controversy involved with this particular topic? And I think the controversy part with this is relatively difficult because there is a very widespread consensus that the criminal justice system in the United States has a lot of problems, and there are very few actual defenders of the system. Like you could say that the core controversy is fundamentally political, and you'd probably be correct. But to me, politics, even though it's an important aspect of the topic, to me, something that is the unique controversy for each topic should be something a little bit different, than just politics. Even though a lot of debates, probably a majority of debates, will amount to various agent arguments and the politics DA. But I do think that there are some other ways to approach the topic, and I'm going to address them here. So the very first thing that I do is, I spend a long time looking for topicality words, defining terms, trying to figure out what the words in the topic mean. And I can't, I don't have a definitive view about what any of these words mean. It's still, for me, it's very early in the process, but I have done a fair amount of topicality work, and I'm going to focus mostly on just kind of the term enact and reform and give you a few definitions of this. So one thing about these definitions is that they're like presented for the PowerPoint view. The actual cards are like quite a bit longer. There are ellipses in here, so you can't do that. But the first thing I want to talk about is the word enact, which I don't actually think provides the negative very much ground, but at the beginning, at first glance, it provides quite a bit of ground. In the sense that, there's evidence like this, and there are many cards that are like this. They're very easy to find that say that the word enact means congressional legislation. And I think this is a particularly good card that defends that particular interpretation of the topic. And that will be a pretty big controversy in terms of it will, this card or cards like it will be in a lot of debates next year where they will just say the affirmative team has to go through the Congress, therefore the negative gets a court's counterplan. This topic is about agent debates and so forth. I don't think that interpretation is going to be very persuasive to most judges. We have some empirical support for that. So other topics where negative teams have tried to do that, they've had very mixed success. And I think that on this topic in particular, the affirmative evidence is easily as good as the negative evidence, and that so much so that I'm not convinced that the word enact will be like a very large source of negative ground. But I felt like I wanted to address it in my lecture because it's so easy to find cards that say that enact means congressional legislation, and the majority of cards, in fact, would define enact as congressional legislation. This is an example of an affirmative card that is not in the context of criminal justice. There are several cards that are, but this evidence kind of addresses the negative argument on its head, says that opponents say that enact means legislation, but the reality is all of the definitions that support these say that enact is frequently legislation. They never say it's exclusively legislation, and courts always, frequently refer to their own created rules as enacted. And the reason why I don't think that this interpretation is going to be a particularly useful interpretation of the topic for the negative is just because from an educational perspective, to say that we should be debating about criminal justice but not talk about the courts as one of the primary focal points is probably a little bit of a bankrupt interpretation. This topic is very much about constitutional law and constitutional interpretation, and probably the vast majority of affirmative solvency advocates from this topic come from law reviews, which more than anything else advocate the court. So to me, even though I think that the negative has a fair chance, there's very good evidence that says that enact is a limiting term. I think the actual reality as it plays out in debates is that it will not affect very many debates. The second term is reform, and this is, this should be a limiting term. Ideally, this is something that would hold the affirmative to something very specific, but the reality is it doesn't actually provide very much help to the negative. And the card that I have here, I think, is very useful in terms of how most articles treat the word reform on the topic, that reform is basically a multi-directional concept. In other words, whether or not something counts as a reform depends upon the goal of the person advancing it. So most people would think that reform means something like just improvement, but you can improve a particular system from a variety of different perspectives. So somebody who believes that the purpose of the criminal justice system is to deter crime and encourage public safety would say that sentencing reform is about making sentences more strict and increasing in overall length of incarceration. Somebody who takes the perspective that the criminal justice system is an unjust institution that has massive disparate effects on different races, would take the perspective of, sentencing reform should probably, eliminate really harsh sentences or disparate sentences. So unfortunately, I don't think that the vast majority of definitions really provide the negative with much of anything, and which is weird because that is the object of the verb of the resolution, is you should enact reform in one of these areas, but reform probably just means a vague version of improvement, which could come from a variety of different perspectives. This card is kind of a card that answers that perspective a little bit, or maybe provides the negative some hope. And there are actually a lot of definitions about this. I don't know that I chose the best one, but I chose one that I think fits part of the purpose of my lecture fairly well, which says that somebody who is reforming a system is somebody who has accepted the premise that that system is built upon. So if you are reforming something, you are accepting that the system should exist, and that is distinct from the notion of abolition. And to me, I'm going to talk a little bit about abolition as a negative strategy, but in terms of the only kind of core negative ground that's built in based off the wording of the resolution, the only controversy that really exists is the difference between reform and abolition, or reform and revolution. And there is a very large body of literature that is focused on this. And my recommendation is, one of the starting points of researching the topic, you begin with some of that research. So I think in the Michigan Starters camp, there's a very short abolition critique. I'm going to give you some cites for a couple of different arguments that I think are make the same argument, but from slightly different perspectives. That I think are a very useful place to begin the topic with. Okay, this is the last set of definitions that I'm going to show you, which are just like different definitions about the areas themselves. These are all relatively straightforward and not controversial. So I didn't include the full cards or the full cites here. I will turn out all of this evidence at some point. I'm not sure how, I mean, maybe in the near future, maybe in the next couple of days. We'll see what I do over the weekend. But I'm going to, but these are like three pretty straightforward, accurate definitions of the different areas. Forensic science is an extremely broad term. It includes a whole lot of things that I had never heard of before. So forensic anthropology, forensic engineering, forensic psychology, forensic entomology, like the study of insects, I think. But it includes a wide variety of fields, and it seems like the common theme of definitions of forensic science is just that it's an incredibly broad term. Policing, this is a pretty straightforward definition of policing that just defines policing as the exercise of power by law enforcement. Unfortunately, the term law enforcement, as you'll see on the next slide, is an extremely broad term that gives the affirmative potentially a whole lot of different options about how to approach that particular area. And sentencing is just the stage of a trial that after somebody has been convicted, it's the pronouncement of punishment. Sentencing, when we kind of traditionally think about it, we think about it as jail time, but there are many, many forms of sentencing that are not about jail time. So it could be fines, it could be probation. There are many forms of alternatives to incarceration that sentencing could potentially involve. So this, to me, is the scary part of the topic. So like the fact that reform is multi-directional isn't that scary to me. The fact that enact doesn't provide much of a limit isn't that, it doesn't make me very nervous at all. But law enforcement, or policing as law enforcement, is a little bit concerning to me in the sense that you can see from this list, it's very, very broad. And some of it's relatively straightforward. So the FBI, the US Marshal Service, the Drug Enforcement Administration, all of those are going to be thematically represented in the bulk of topic literature. And you can see like immigration is probably, it's a separate area, but very difficult to exclude from the term policing, in my opinion. It's also very difficult to exclude from the term criminal justice. I've tried to, I didn't include any definitions of criminal justice in this presentation, but from what I can see, it doesn't really exclude any of these agencies. And then you can see things like the Coast Guard or the Secret Service or the Transportation Security Administration or the Office of the Inspector General, which investigates other federal agencies, but actually has law enforcement officers that are armed and with search authority and arresting power. All of that probably is included under the rubric of policing. So from that perspective, I think the topic is potentially very, very broad, like one of the broadest topics we've ever had. Having said that, I do think that the topic literature is very interesting, and there are good negative arguments on the topic, and I'm very excited to begin or continue, in my case, just researching the topic and seeing some of the debates on the topic unfold. Okay, that was a duplicate slide that I meant to delete. Okay, so I have a chart here which kind of gives you a little bit of background about the system of prisons and jails in the United States, and this chart, I'm not sure how well you can see it, but this is 2020 data from a website called the Prison Policy Initiative. And if this is hard to read, I would really recommend going to the URL that's at the bottom of this, because it gives you a lot of pretty strong topic background. So I wanted to just talk a little bit about some of the important things. So the United States has the highest percentage of the world's prisoners. It has about 5% of the world's population, 20% of the world's prisoners. The total number incarcerated is about 2.3 million, but there are 4.5 million people who are under the supervision of the criminal justice system, which means they could be out on parole or probation or under some alternative sentence to incarceration. It could be that they're just in debt and they have to pay fines to the criminal justice system and face the threat of police power if they don't pay those fines because it's actually part of their sentence. So the overall population that interacts with the criminal justice system is much, much larger than 2.3 million. And that's significant because even if you don't have jail time or prison time as a result of your sentence, there are a host of criminal consequences that are pretty severe. So if you are convicted of a felony, even if you serve no jail time, you still are very likely to find it extremely difficult to get a job. You are probably excluded from public assistance. You are probably poor to begin with. Statistically, you're much more likely to be poor to begin with, and you're excluded from public assistance, which means that you are likely to be in a permanent state of economic deprivation as a result. There's also, so the difference between prison and jail. Prison is where you go if you are convicted of a felony, which is a much more serious crime. Jail, there are two types of people that go to jail. One is people that are awaiting trial but can't pay bail. They stay in jail. And two is people that are serving misdemeanor offenses. So a misdemeanor offense is generally any crime that has a sentence of up to 1 year. So even though at any given time, there are only about 600,000 people in jails, in any given year, there are about 10.5 million people that go to jail in that year, but most of that is likely misdemeanor offenses. And just focusing on incarceration statistics doesn't really give a true picture of the criminal justice system because there are many, many more people that are arrested and searched by the police or stopped by the police or then are actually reflected in the carceral system itself. There are some other statistics here. So immigrant detention is actually about 70,000 if you include all of the statistics. So the one in gray there that says 42,000, I believe, is just at the state level, and then there's still a federal level for immigrant detention. There's also, so like the US military has its own military justice system that I've seen evidence that says falls under the criminal justice system. It's very small, it may not be substantial, but it definitely exists. The US territories have their own systems. So like Puerto Rico has a system that's distinct from the states and so forth. About 20% of the people that are arrested or not arrested, but incarcerated are for drug crimes. More are arrested for drug crimes than are incarcerated for drug crimes. Okay. Another important background piece is that the vast majority of criminal defendants are indigent defendants, which means that they are in poverty and they cannot afford to pay for their own lawyer. That means that as a result, they are usually represented by a public defender, and public defenders' offices throughout the country are extremely underfunded and overburdened, which means the overwhelming majority of criminal cases are done through plea bargains and not trials, where the prosecutor gets somebody to agree to a deal so that they don't actually see a courtroom. So the statistics here are like pretty overwhelming. So like there are fewer indigent defendants at the federal level than there are at the state level, but there's still 66% of federal defendants. The 89 to 90% variation really depends upon the year the statistics were taken. And I'm not actually sure about the most current ones. I think the most recent data I saw was from 2011. If you can see from the graphic that the overwhelming majority of cases at the federal level are pled out. So 2% go to trial. And at the state level, it's actually about the same. It's about 2 to 3% depending upon the state. Some cases it's even less than that. The other thing that is, really important to understand for the criminal justice system is just that there are massive racial and ethnic disparities in correctional facilities. This particular chart is only about the incarcerated population, so the population that's in prison. It is not about the population that is arrested or stopped by the police or harassed, in which case these disparities would be much more severe. But this chart, I think, is telling. So 64% of the US population is white. They represent 39% of people who are incarcerated. 13% of the US population is Black. They represent 40% of the population that is incarcerated. One thing to know is that there's pretty good evidence that says that Blacks and whites commit crimes at about equal rates, but the disparities have to do with disparities in policing. So like who do the police decide to arrest, and disparities in prosecution. So who do prosecutors choose to charge with crimes, and who do prosecutors let go? Like you'll see, like with the abolition literature, like race is probably like the predominant theme throughout, is that the criminal justice system is grossly targeted towards people of color, and in particular, Black people. Okay, so I'm going to go through this a little bit quickly, just because I'm like running close to the end of the time that I had allotted for this. But I wanted to talk about just like, what are the goals of the criminal justice system? So as we traditionally think about them, the goals fall into these 5 categories. So rehabilitation means that you would have somebody who committed a crime re-enter society and be a healthy, functioning member of society that's unlikely to commit a crime again. Incapacitation just means that somebody who murdered somebody should be in prison so that they don't go and murder somebody again. So it's a public safety rationale. Deterrence is also a public safety rationale. So we have penalties for things like murder to prevent people from wantonly engaging in murder, I suppose. Retribution, which is sometimes called just deserts, is the notion that if you commit a crime, you should be punished for that crime because you have committed some harm to the community, so you deserve to experience some harm on your own. It's like, if you think about it as like it's an eye for an eye style of justice. And restitution is the offender making good to the victim, by paying them, a fine, usually to pay for their crime, and that's particularly true in the context of property crimes. So you could see a lot of different lists. There's some lists that might be shorter than this that don't necessarily include restitution. There are other lists that are a little bit longer and have distinctions. But to me, these are like the 5 broad purposes of the criminal justice system. And the overall lesson from this is that the system fails badly at meeting any of these purposes. So that's, both the affirmative and the negative will probably agree on large parts of these points. So if you think about rehabilitation, if you judge rehabilitation by the likelihood that a prisoner commits a subsequent crime, then the system is a total failure, because after 5 years, about 76% of people reoffend. They commit additional crimes. A large part of the reason for this is economic. So the vast majority of criminal defendants are indigent. It actually, their pre-incarceration income averages to less than $20,000 a year. So they have very little economic means. They lose access to public assistance upon committing felonies. They have no safety net or no program to ensure reentry, so therefore they are likely to reoffend. So there's widespread agreement that the system does not succeed at rehabilitation. In terms of incapacitation and deterrence, if either of these goals were successful, then we would see, as incarceration has increased, crime should have steadily decreased. And the incarcerated population started at, well, it didn't start, but in 1970, it was about 300,000. It massively escalated through the 1980s and 1990s as a result of the war on drugs to what it is today. So it has hugely increased, but crime rates have actually fluctuated greatly over those periods. And there are like pretty strong studies that say that, reasons for crime rate declines are usually tied to improved economic prospects, or just the aging population, because you're much more likely to commit crimes when you're young than when you're old. This particular chart just demonstrates states that have decreased incarceration. Many of them have seen a decrease in crime. States that have increased incarceration, some of them have seen an increase in crime. The chart, I think, kind of goes through most states and demonstrates that there's not really a correlation over time between crime rates and incarceration, which means the system doesn't really actually have much of an effect on those things. Retribution is an interesting one, because retribution is something that, if it were true that we thought as a society that everybody should, pay for their crime, that if you commit a crime, you should do the time, then we aren't doing that very well, because over 70% of American adults commit crimes every year that have the possibility of imprisonment. And, a lot of them, they don't even know it's crimes, or they're accidents or mistakes, or it could be like different traffic offenses, but all of them carry the possibility of imprisonment with them. And it's about who we choose to enforce crimes against. And one, I think, important takeaway is that both policing and prosecution are completely discretionary. So some of the authors that I read to prepare for this lecture, one of them gives an example of street gambling is illegal in a lot of different states. There's a lot of policing resources that are directed in inner cities that crack down, that arrest people for gambling on the street. Street gambling probably has no real public safety justification behind it. It's just a crime that we choose to enforce. Whereas other forms of gambling, such as like speculation in markets, or CEOs that take risks that actually violate the law, or like the housing market crash from 2008, all have much larger effects. And yet almost nobody ever goes to jail with that, because we have chosen where we have concentrated our policing and prosecution resources. What we've decided is more important as a society, are things that, we aren't punishing people for the crimes that have the biggest effects on society. So for example, we likely committed war crimes in Iraq, and yet there's no criminal prosecution, and those crimes had much larger effects on overall public safety. And then restitution is also interesting because the majority of defendants are indigent. If you force them to pay fines, that sets up a system of actual, effectively, debtor's prison, where they go to jail for the inability to pay their fines, which the Supreme Court ruled in 1983 was illegal, and yet it still continues today. And there are many different statistics for it. The ACLU has a relatively recent report on it that say that paying restitution actually contributes to the problem of incarceration, and it locks people into permanent economic destitution. And the worst part of that is most states, for people that can't pay their fees to the state, or restitution, which is like the majority of defendants, most states will contract those services out to private collection agencies, where that will add on to what they have to pay. So in Florida, for example, the private collection agency can charge a 40% fee on top of whatever they're trying to collect. And sometimes people go to jail for just the inability to pay, which seems like it should be illegal. I'm not really sure why it isn't enforced, because it is definitely illegal, but nonetheless happens, and depends on the state, but in some states it is relatively frequent. Okay, so the very last thing that I'm going to talk about is just abolition and some research tools. So if you think about the goal of the criminal justice system to meet any of those 5 punishment goals, then that system has totally failed. There's widespread agreement that it does not actually do that. But if you think of the criminal justice system instead as a tool to maintain power of white elites and maintain racial or economic hierarchies in society, then the system is succeeding beyond anything that it was originally intended at. And the case against reform, for which there are fantastic cards, say that reforms legitimize or prop up this system of white supremacy, that the criminal justice system itself is a system of white supremacy, that reform eliminates the most visible or grotesque parts of that system, but keeps the overall system of mass incarceration intact. And even if it eliminates some of the incarceration part of mass incarceration, the criminal consequences to just conviction are so severe that it nonetheless still does its job of maintaining those particular hierarchies. So to me, like an initial negative position to invest in, I think, is to do a lot of research on abolition of the criminal justice system, because the literature base for that is really, really rich and diverse, and the evidence quality for it is ridiculously good. And like some of the better, much, if you read critiques last year or looked at any critique evidence last year, the evidence last year by comparison is absolute trash. The evidence this year is very, very strong for like a variety of perspectives, but the reform versus abolition part for a link part of a critique is extremely good. And so two places to begin your research with. So the first is this book from Michelle Alexander called The New Jim Crow, which is a claim that Jim Crow laws were ultimately replaced by the system of mass incarceration, which serves a very similar function. This book to me is like the best introduction to the topic that you could read. It does obviously cost money. It is available through Michigan databases. So once you have access to those databases, like I read the ebook version through Michigan and carded it, but it is to me the single best introductory resource to the topic. So if you have a copy, or if you can buy a copy, or you can wait until you get library access, I think it's a very strong place to start. The other one is this book from it's Alec. I wrote Alex, but it's A-L-E-C, I think. Alec Karakatsanis, who wrote a book that's based upon 3 essays. So like I actually bought this book, but to me it's like some of the best critique cards I've ever seen. And if you can't buy the book or can't access it, like the book wasn't part of the Michigan library, but the link that I have here, if you just Google the phrase "the punishment bureaucracy," you will get his first essay, which is basically about half the book and like the good part of the book, the part that is just a damning indict of the criminal justice system as currently practiced, and is an extremely strong case against reform. So I would encourage you to start with that, because that is definitely freely available and you should be able to read it yourself. If it's the first thing that you read on the topic and cut cards from, it's a pretty good place to begin, because there are like a million cards, and to me it's an excellent introduction to the topic as a whole. I think Alexander is better, but Alexander is less accessible because it's a book that you have to pay for. And then this last thing, so I'm going to just like maybe post this on HS Impact, but I created a Google custom search engine, which is Jason Peterson gave me a bunch of different links, and then I found a lot of links on my own, and I'm constantly adding to this, but it's essentially just a way to do targeted criminal justice system work or criminal justice research that is not a great place to conclude your research, but as an introduction to the topic, where you're looking for a lot of different articles that explain it. If you have time at home to do research and you want to do a lot of reading, this engine I think is very accessible. To me, the best place for research is law reviews, which you can get a lot of them online, but you'll get the best ones when you actually have database access. But until you have that, I think that this Google custom search is a very strong tool, and I'm adding to it every day. I think I added 3 links to it today and a few yesterday, and I'll continue adding to it as the year goes on. I did one for arms sales that I shared with my lab, and I'm just gonna I'll probably just ask somebody to post this on HS Impact or something like that. So that's all that I have. And I guess now we have time for questions.
Well, thank you very much, David. We should first mention that Alec Krexanis will be lecturing at the camp this summer. So that's something to look forward to, as well as many other scholars in the field. So be excited about that. We had one overwhelming question, which was, what is the name of your cat?
I have two cats. One is named Coco, one is named Snickers. I don't remember which one was in my lap. I think Coco was.
On questions of arguments, we can start with some of the K questions that people had. The first one is, what type of non-identity critical literature do you think exists on this topic?
Well, so to me, the abolition critique doesn't have to be an identity critique and is an access point to many other types of critiques. So Karakatsonis, for example, makes a strong argument against, in favor of abolition, but he also very clearly says that he thinks that capitalism also needs to be abolished and that you could start with capitalism. There's, and then, his book also, quotes Foucault, and the line, a lot of different authors talk about biopower, which on prior topics has been a pretty present theme in critical literature on criminal justice topics. And it is, just from what I've done research on, like I wrote a version of the abolition critique already that is very preliminary, but what I've done research on, I just searched the term radical criminology, and it is an access point to a wide variety of critical authors. Most of which I haven't read. Like I said, I put together a file that, but there's, I've barely scratched the surface. There's a good site that's represented in the custom search engine called the Abolition Journal, which also, accesses both identity and non-identity based arguments in favor of abolition. It's well worth your time if you're interested in doing critique research.
Well, great. Can you briefly explain the difference of reform and abolition?
So based off the card that I had, and this is just a definition, but there are, many other actual, cards that aren't definitions, but describe the difference between reform and abolition. So reform is something that tries to improve the system. And abolition says the system is not redeemable. The system is not improvable. The only thing that should happen is the elimination of the system. Now, what abolition actually looks like in practice is there's a lot of disagreement about that. And there's certainly grounds for like a very powerful affirmative permutation, but having said that, there are also very powerful permutation answers. But like the crux of the difference between the two is, if you're believing in reform, you're improving the system by keeping the basic structure of the system intact. So the line of this card, I can't actually see this whole card on my screen just because of the picture windows blocking part of it. But but it says reformism is what accepts the system as it is. It thinks that the system can be changed. It thinks that the faults of the system are about how it's carried out. So somebody who was a reformer might say that there are gross sentencing disparities. So for example, there are mandatory minimum sentences that have, in 1986, there was a law that said that, if you went to jail for crack cocaine, your sentence was 100 times more severe than if you went to jail for powder cocaine. And that, that crack disparity was because crack cocaine, even though it's chemically the same as powdered cocaine, was predominantly used in minority communities, whereas powdered cocaine was used in wealthier white communities. So there was a massive sentencing disparity. And while that disparity has been reduced to 18-1, it still exists. And a reformer would say, this system's really racist, we need to eliminate these disparities, where somebody who's abolitionist would say, the problem is not the length of time that people serve. The problem is that the overall system is designed to maintain the power of elites, of either whites that are in power, so white supremacy, or the power of capitalism, depending upon your perspective. But an abolitionist perspective would just say you have to get rid of the system entirely, because even if you removed these racial disparities, the overall system is nonetheless going to be targeted at race. And like the fact that most cases don't even go to trial means it's very difficult to enforce a lot of the protections that affirmative teams will try to do. And policing and prosecution is discretionary, and they will use that discretion to make racially targeted judgments regardless of what the law actually requires.
Well, that is a very robust explanation. Thank you. Let's segue on to T a little bit, and we can stay on the topic of reform. If reform can go both ways, how do you think the negative should approach the bidirectionality debate?
So I don't have a good answer to that right now. I think that agent counterplans will definitely be a big part of the topic. The state's counterplan will be a big part of the topic. I think the affirmative is probably a little bit better positioned against states than it was on the education topic, but it's still going to do a lot of work for the negative, regardless of the direction of the affirmative. Like the vast majority of criminal justice of the criminal justice system occurs at the state level or the local level. And then, like, regardless of what I said about enact, like, while I think that the affirmative is fairly well positioned against the word enact, if you look on prior topics, negative teams are still going to read agent counterplans, and they're going to be somewhat successful with those counterplans. It will depend upon the quality of debating, but from a generic perspective, the negative has a lot of options. And then you can think about, like, just what are the types of strategies that negatives have read against large topics in the past. They've invested a lot in critiques, and the critique literature on this topic, to me, is, I generally think critique literature on domestic topics is always better than international topics, but to me, it's like, this is the best domestic topic for critique literature. And I think that will be a very, prominent feature of the topic that will address a wide range of affirmatives. And I think that there are going to be a lot of different process counterplans, because it's a legal topic. There will be, there are always process counterplans on legal topics. And I don't know exactly what those will take, but if you look at the Michigan starter files, you have some examples of those process counterplans that, right now are in their very introductory form, but as the summer progresses, will obviously become quite a bit more robust.
That answers the question, a very popular question about negative ground. What do you think common DAs will be?
That is really tough. The politics DA is going to be very good in the first semester. It's going to be the elections disadvantage. There's a very strong version of the elections disadvantage in the Michigan starter set. There will be obviously a lot of courts disadvantages, and I would expect probably the majority of affirmatives will prefer a courts agent, mainly just because that's where I think the better literature is. And I'm somebody that doesn't generally like courts topics. Like, I usually think that courts debates are pretty bad, but on this topic, I think they're going to be quite a bit better than they otherwise would be. So the negative, well, at the beginning, we'll at least have to invest in politics and courts disadvantages. As far as generic other disadvantages that aren't agent related, I don't actually know the answer to that. Like, there are some options that are proposed in the topic paper, like federalism and like, I think a police backlash disadvantage or something like that. I'm not like super thrilled about either of those arguments. But I think that, the negative will have a very strong circumvention argument for the majority of AFs. So a lot of the times, politics plus circumvention, or politics plus an agent counterplan, will be a pretty strong approach.
That's excellent, as well as it can be. How do you predict that substantial will play in writing AFs?
I don't know. I've done a little bit of work on it. The work that I've done has not been very satisfying. In the past, really like the past three topics, I thought substantial was a source of like fairly good negative arguments that, obviously like weren't slam dunk arguments for the negative, but gave the negative like a fighting chance against super small affirmatives. Here, the reason it worked on prior topics is because it modified something that was generally quantitative. Here, substantial reform is really up in the air. I've seen some cards that talk about major reform. None of them have been good enough that I would be like happy, like turning them out as evidence. But but to give you an idea of what we're dealing with, like if you were to Google the phrase substantial criminal justice reform, there are a lot of different articles that use relatively the same quote from, I think, the Sentencing Project that describes the First Step Act, which was the criminal justice reform that passed in 2017, as like the most substantial criminal justice reform that's passed in decades. And like, while that's true, it's expected to affect about 1,000 prisoners annually and 3,200 prisoners at the very beginning. And like, but even using incarceration as a metric to compare substantially to is completely wrong, because the topic is also about policing and forensic science, which are only very indirectly related to incarceration. So to me, my initial reaction to substantial is that it's not going to do very much, if any, work for the negative. I've been wrong about things like that before, but I'm fairly pessimistic about it right now.
Well, that is interesting. Hopefully that changes a little bit for the negative sake. Do you have any initial thoughts on topicality for non-traditional jurisdictions like reservations and ICE detention facilities?
So if you're talking about for reservations, the topic doesn't say it's criminal justice system. It says criminal justice system or criminal justice reform in the United States. So to me, it's the only question is like, do reservations count as part of the United States? And while there are cards that say they don't, because they are separate sovereigns, there are also like fairly good evidence that just says that geographically they're part of the United States. So I feel like that is going to be difficult to exclude. ICE detention facilities, as long as it falls under the definition of criminal justice, I don't think that there's and they're obviously geographically located in the United States. I don't think there's really a topicality problem for the affirmative for that. Although to me, I think it is a little bit weird. So ICE detention may not be topical because the topic isn't about detention, is only indirectly about incarceration, but it's very much about policing. So stopping ICE from conducting workplace raids to me seems topical, unless it could be excluded under the term criminal justice, which I have not seen evidence to suggest that, and I've seen evidence that suggests the opposite.
All right. Well, our last question is a two-parter. What do you think the most common apps will be at the beginning of the season? And if David Heidt was a 2A debating on this topic, what app would you be reading?
Most common apps, to me, I think the ICE immigration app is a pretty promising area. I have like a very tiny question about topicality, but so I would do that work first, but it's a debate that I expect the affirmative will prevail with. And just from prior knowledge, like there's an entire area called crimmigration, about the intersection between immigration and criminal law. And that is an extremely promising research area. As far as the app that I would read if I were a 2A, I'm not 100% sure. I would think about an app that had an angle against something like the reform or versus abolition critique, just because I expect that critique will be a large part of many debates next year. What that app looks like, I don't know. But this is one of the, like I said before, it's generally, I don't really like courts affirmatives, but this is one of the few topics where like I would personally probably want to read a court's affirmative, just because to me that the stronger solvency advocates are in that area. But this is very preliminary. And right now, like I like the death penalty act. I've done a little bit of reading in that, but I don't think I could make a decision about what app I would want to read next year. I think there are many ideas that are all like pretty strong. So.
Well, great, and thank you for your time. There are plenty of other great questions that we did not get a chance to get to, but hopefully by the time camp starts, you will have those questions answered. So we look forward to working with you this summer. For those of you who are not part of the camp and are interested, please visit michigandebate.com and or contact Aaron Call at akall@umich.edu. Thank you very much. Thanks, David.
My pleasure.